All right, welcome everybody to this week's edition, episode 2 of Legalese with John Watts and Stephen Palmieri, yours truly, where we make it easy to understand, have fun, be entertained, and learn about everything and anything legal-wise in the credit world. John Watts is joining us today, my co-host on this show. John is an extraordinary, world-renowned consumer protection attorney, YouTube channel with like 15,000 fans. John, welcome. How are you doing today, sir?
Good. How are you doing?
Man, doing good, man. Always good when I'm doing a show with you, buddy. And so I know we were talking a little bit before the show, and you were saying, Steven, man, you've got some pretty exciting litigation cases that you've been working on and are working on, and you want to share that with our audience here. And obviously, for those of you who are watching, feel free to comment below. And we want it to be an interactive show. But so, John, give us some kind of juicy things, man. What's on your plate these days? What's hot with the credit bureaus and the litigation arena?
Yeah, and just to sort of emphasize what Stephen said, definitely put in comments, and we are trying to monitor those and any questions you have, and that will be more exciting than just listening to the two of us ramble on. But I will mention a couple of recent cases that we have filed or we are filing. So we filed one, I guess it was Friday or so, against Midland Funding, Midland Credit Management, and then the three bureaus. And that's where our client was sued by Midland. He won his case. Then he goes to the bureau, says, here's the lawsuit. Here's the order where I won. Get this off my credit report. And they all said, nope, we're keeping that on your credit report. We're going to update it with the full balance. And so we're suing under that because that's just a slam dunk. We've got the court order saying we won the case. We do not owe Midland any money. And yet they're keeping it on our credit reports. And Stephen, you and I have talked about this. There's this argument about legal and factual, and the bureaus are trying to say everything is a legal dispute. And so they don't have to investigate it. If you think through the implications of that, they would never have to investigate identity theft. Like, hey, that's legal. Like, I don't know, do you really owe it? Do you not owe it? And so it's this bogus argument. And they say, well, judge, if when they get sued, they go, if we just had a court order telling us what to do. Well, here's an example, court order, and they just absolutely reject it and verify it. So we've got a number of those that we're filing, and I just like them because they point out the hypocrisy of these credit bureaus that, they don't really care about this legal versus factual. They just don't want to do any disputes at all.
Yeah, forget about the fact that the law requires maximum possible accuracy, and you literally sent them a court order showing that it should be gone. So, and that's the thing, with these, when you litigate against these companies, basically the cost of litigation is really built into their business model. And quite frankly, they make so much money, they print so much money, and the damage provisions in the FCRA for negligent and willful noncompliance, what is it? I think it's $1,000 per violation, technically, right? Is that plus maybe plus damages? But it's not like some big giant statutory fine, right? They're like, oh, well, it's just a little mosquito bite, and so we'll just swat them away when they come to us. How do you feel about that?
Yeah, and that's how they look at them. They're not looking at them quite right. So if you do have a willful violation, you can get statutory damages up to $1,000, and you get punitive damages. There's really kind of two things that drive these cases. One is the attorney's fees. If they say, we're going to fight you, we're going to make you travel all over the country, pre-COVID, we're going to make you write all these briefs. It's like, great, then you pay my hourly rate. But the other thing is the compensatory damage part. And there's really two aspects to that. One is economic. So let's say there's false credit reporting. I dispute it, they don't fix it, and I get a loan at 5% interest instead of 3%. Well, that gap, that's my economic damage. So we take that out 30 years, and then we bring it back to present value, and it's a lump sum of money. But then the other part is the emotional distress. Now, all the bureau lawyers say you can't get emotional distress. No jury will ever give you emotional distress. Well, the funny thing is, when we try these cases, somehow we get emotional distress. Now, our background is personal injury, so we're used to fraud cases and, proving emotional distress. And so that's a big part, because you think about how frustrating it is. You have no control over whether Equifax, Experian, TransUnion keep a credit report on you. But you do have this one thing. You say, I have the right to an accurate credit report. And if it's wrong, I can dispute it. So you dispute it and they just ignore you. Well, that's insulting. Obviously that's very, very upsetting to have that happen. Now, again, these lawyers in the tall towers say, well, I don't think anybody would be upset by that. Well, the funny thing is, you get the most conservative, business-oriented federal judge, and a bureau messes with his or her credit report, they go ballistic. And when that happens, now they understand. The judge is like, okay, I see why people get upset about this. So, we think the cases have really good value, and the bureaus disagree, and until we agree, they don't get settled.
Everybody's a consumer at some point in time, including those judges, right?
They are.
So,
They are.
And I've seen some things recently kind of posted up, and I don't know if you've got an opinion on this or not, but like some theories where, because the bureaus are they're like publishing like a commercial report in your name and using your name, does that entitle the consumer to like say, well, you're publishing this report in my name, using my name, so you should give me royalties or something from it? I mean, have you seen those kinds of things where they are using your identity to publish something for commercial use? What's your take on that?
Every now and then I'll see stuff like that, but the federal law, that's going to trump any state law. So invasion of privacy is state law. This is above it. And the law, the Fair Credit Reporting Act, gives them the right to publish to a user who has a permissible purpose. So really your remedy is if they impermissibly allow somebody to pull your report. So you sue the company that pulled the report illegally, and you sue the credit bureau for allowing that to happen. But just in terms of saying, hey, every time you publish my report or Stephen, your report, we should be entitled to money, that doesn't work. So it'd be nice.
So what if your name is trademarked, like my name actually is trademarked, it's my brand. Literally, I've got the USPTO Stephen Palmieri. But when you do that, you kind of put your categories in that you're trademarking, right? What if I were to trademark my name for, I don't know, commercial reports or something like that? Like now you've got, is there any way you could checkmate these folks and be like, look, you're using my name for something that I've got the trademark to? We're just kind of talking, since we've got we're just talking theoreticals and hypotheticals. But what could you do to bring some fancy argument to these folks and really raise the heat on them if you wanted to?
Yeah, I mean, look, that's a clever angle. I think at the end of the day, the judges go, that's really cute, but no.
You're like, congratulations on your personal brand. Now move on out of my
right.
We've got something else we've got some asbestos case coming up after you, something, right?
That's right. That's right. Don't let the door hit you on the way out.
Yeah. So, but I mean, it's a good point, because like you said, you've got the FCRA, and once they've written the federal law, it pretty much lays out the framework under which these folks can operate. And, I think it's important for our viewers to really understand how that framework is designed, because, if they're wanting to kind of do the pre-litigation type concept, which is really, try to checkmate them with letters that you can hand off to an attorney such as you, it's important to kind of know, what you're doing and what the general rules are. And, interestingly, I'm not sure if many people really give much thought to it, but, it's one thing to have inaccurate information, but it's another thing to say that their procedures weren't reasonable, right? That they didn't do what they were supposed to do. But yet, the way that the judges are these days, you really have to be able to kind of tie both of those things together, right? Because, it's a really high standard. If you're just going to sue them for inaccurate information, you have to be able to prove like defamation and malice and things like that. But if you send them the notice that the information is inaccurate in a dispute, what they are required to have, and really kind of what you're suing against, is whether their procedures failed, right? Did they take your letter? Did they properly reinvestigate? Did they forward it to the furnisher? Did the furnisher reinvestigate it? Did that procedure, that mechanism that Congress created, fail? And so, it's it's one thing to say, this information is inaccurate, but are you giving them proof that it's inaccurate, right? Like, are you giving them enough information to get a kind of above the level to where if they don't fix it, you can say your procedures failed. And what I mean by that is, are you putting a copy of the credit report page in there so you can show them and be like, hey, here's I'm not just telling you what's wrong. Here's a copy of your own report that you've printed, that you've published, so that they can see it, because we all know that their reports look different, like every single one, each different report source. I mean, we've talked about this. You can go to annual credit report Experian, and that's different than the direct portal Experian, and that's different than the paper Experian that they mail you. And they're all Experian full file reports, and yet they all literally look different, right? So, from your perspective, do you see a big difference between, sending in a dispute and giving them a copy of their report with it and really kind of saying, hey, here's everything you need to see what you did and what you should be doing, versus just like, a letter that doesn't have any of that substantiating information attached to it?
Yeah, I mean, it certainly is an option to include the credit reports. I'll just tell you, usually we don't, but we're very specific. We don't just say there are inaccuracies with that capital one. We say there are inaccuracies with the capital one with the payment history. But then we go on and we say, for example, in May 2018, Equifax, you say this, Experian, you say that, TransUnion, you say this. And so we spell it out very carefully. So I'll give you another example. Like if you're disputing, let's say a debt buyer on your report, and you're saying, hey, there's no date of first delinquency. Experian and TransUnion will just have the estimated removal date. Well, sometimes you can find the original creditor on there and look and see when that's supposed to come off, because that should be the same as the debt buyer, but it's usually not. There's a discrepancy. And then look at the payment history for the original creditor. So, I mean, we really have to kind of tear these reports apart in detail and then kind of spoon feed it to the bureaus. So, if somebody comes to me and says, hey, I want you to sue, here's my dispute letter. It says, please validate this debt. Well, that doesn't do anything. Or if it says there are inaccuracies in this, I'm like, well, what inaccuracy? Like, we need to tell them. And the easiest way I know to think about this, Stephen, is, the Fair Debt Collection Practices Act, when we're dealing with the debt collector, that is strict liability. I mean, they break the law, they're liable. That's it. Like, they don't have to have bad intention, be careless, or anything. Fair Credit Reporting Act is not that way. We have to show negligence. Well, that's a legal word. What does negligence mean? It means failure to use reasonable care. Well, what does that mean? Well, the easiest way to think about it is just driving a car. When we drive a car, we say, well, I've got to go at a reasonable speed. I have to keep a reasonable distance. And so driving down the interstate with no traffic at noon is different than it's midnight and there's poor visibility and one of your headlights is out. I mean, you gotta adjust based on circumstances. So if we give a credit bureau just this generic dispute, hey, there are inaccuracies, fix them, they don't have much obligation. But if we say, here on the payment history and the date of first delinquency, and look, the open date and the close date, and we go through every field, now they have a lot of information, and now they have to drive very, very carefully. And if they don't, they're negligent. And that's what we're looking for, is negligence, or even a higher level called wantonness or recklessness or willfulness.
And, interestingly, so Ali posted up in here, she says that Synchrony Bank sends back letters stating that the credit reports from credit monitoring companies are not considered, quote unquote, correctly reporting when she sends them copies of the credit report. And so that's amazing. That's great. So then I would respond back to Synchrony Bank and I'd be like, great, thank you. So, we've now given you information and you've acknowledged that it's not correctly reporting. So what have you done to fix it? Or can you go ahead and send me a copy of the form, the AUD form or the ACDV, showing exactly what you have reported? Because if you're going to sit here and assert that this is a worthless report, then, I mean, you got to send me something other than just basically saying you're not going to acknowledge that the data is the data. Because, and I mean, kind of to back it up a little bit, yeah, the monitoring reports are not really always the best reports to use because they are these third parties, and they always do kind of, the data is always kind of crazy reporting, whereas the best reports to use, and the ones, John, that you'll only use are the credit file reports, the direct ones that you get either from annual credit report or the paper ones that they mail to you, or their portals if you log into the bureau portals directly, right? Because those are technically the full file disclosures, which are supposed to be everything. But John, I mean, if you had a furnisher write back to you when you gave them a copy of, even if it's a monitoring report in a dispute, and they wrote back and said, "Oh, well, we know that this is jacked up data." I mean, how would you use that to your advantage, and what would your next move be if you weren't obviously like just going to sue them as a lawyer, but if you were a credit repair company and they just gave you something juicy that was like, thanks for sending us this inaccurate credit monitoring report, how would you respond to that to get some leverage?
The first thing is you've got to figure out, are they right? I mean, it may be that it's just reporting differently than they furnished to the Bureau. So, make sure you pull the Bureau reports, actual reports, and then lay those side by side. And you may find some differences. Like I find the payment history on, I don't know, Identity IQ or Smart Credit, that I don't know that that's worth anything, frankly. But most of the other data is pretty good. And you may find that it's exactly the same on the Bureau report. So what does that mean with synchrony? When they say, "Oh, no, that's not right." You're like, well, here's what it says on Equifax. And I know you and I have talked about this, Steve. I mean, it's always good to communicate with the furnisher, but for FCRA liability, we have to go through the bureaus. So it's great if you want to copy the furnisher, write to the furnisher directly, but you have to go through the bureaus, Equifax, Experian, TransUnion. So, if they tell you that, then it's worth sort of taking a step back and saying, well, let me make sure I've got the full reports. And I understand it's sort of a volume business. It sure is a lot easier to use the, Smart Credit and those types of guys. And we use those as well. But if somebody's raising an objection to them, you've got to get the real reports. And, it's kind of like the same thing if they say, well, Stephen, we don't think that your client really sent this because it came from a different zip code. Well, okay, first of all, what does that mean? But address that, don't just ignore it, like address it. Hey, we use a mailing service or whatever. And, I don't want to stand in line with, the pandemic in a post office. Like I'm uploading to certifiedmaillabels.com. That's who I use. And so we want to take whatever they send us and then flip that back on them. So, okay, well, we know this is false from Smart Credit. Explain to me what's correct about Equifax. Or like you said, send me the data that you're actually sending the bureaus. You're doing that in some form or fashion. So, we just, sometimes we get in a rush. We want it fixed immediately, but it's sort of like a tennis match. We fire something at them, they may come back. Well, let's acknowledge it and then let's respond to it and take away any excuse that these guys have.
So something like, "Dear Synchrony Bank, thank you for acknowledging that the report that I sent you is garbage. Just to be clear and to help eliminate my confusion, can you tell me specifically how you're reporting every data field on here that you just said was inaccurate? Signed."
That'd be pretty easy. Yeah.
"Signed with love, Mr. Consumer, represented by CRO."
Right.
I mean, and send that, like to their chief executive, and let them not respond, and give that to John Watson. See if that doesn't make him salivate, right?
And you can always take, like if you get a letter from Synchrony Bank and they say that Smart Credit's not right. Well, take the Smart Credit, take the letter from Synchrony, take the real bureau reports, dispute again to Equifax, Experian, TransUnion, and say, well, look, I don't see any difference here. Maybe you can get Synchrony Bank to tell me the difference because they ignored my letter where I asked them to explain the difference. And so you're just sort of slowly building up that evidence that they're not doing a legitimate investigation. This is all just stall tactics. I can't remember if I mentioned this last time, but we'll have Experian say, we refuse to investigate because you didn't include your driver's license and a utility bill. Well, we did include the driver's license and the utility bill. It's just a form letter. They're just like X number of percent. We're just going to reject them. And so Now think about the implications of that. First of all, we can sue them just for that. But maybe we send them another letter and say, hey, you sent me a form letter saying I have to have my driver's license utility bill. I did include it. I'm including another utility bill with the old utility bill and with my driver's license again. Don't send me a form letter. They send you another form letter back saying, Stephen, we can't investigate without your driver's license. Well, what are they going to say to a judge when we sue them for that? They just look horrible. And so, let's use their own incompetency and dishonesty against them.
And when you sue, I mean, do you typically sue both the bureau and the furnisher, so there's no empty seat, so they can't like point the finger at the other one?
Yeah, that's our preference. Now, sometimes, and not that I ever want to say anything to defend the credit bureaus, but sometimes they really don't know. It might be something really between you and the furnisher, and the bureau has no way of knowing. So we won't sue them then. But the default rule is we want the furnisher there and we want the CRA, and they can point the fingers at each other and we're like, hey, that's fine.
I mean, if you're going to invite your neighbors over for dinner, you got to invite both neighbors, right? That way they don't get jealous.
Yeah. And look, here's one reason. We sue just the bureaus, and they say, well, we sent this to a furnisher. Furnisher did this investigation, told us this was right. Okay. And so they're trying to blame the furnisher. So we want the furnisher in there. But if we only sue the furnisher, and I know lawyers that have been burned on this, they only sue the furnisher. And then once the statute of limitations has expired, the furnisher says, oh yeah, by the way, we never got notice from the credit bureau. You have no liability against us. And now it's too late to sue the credit bureau. So we sue both, and we put in our lawsuit, the credit bureau notified the furnisher as required. Next paragraph. Alternatively, the credit bureau did not notify the furnisher and thus violated the FCRA. We don't know, because this is a secret thing between these two companies. We'll sort it out when everybody raises their hand under oath. And so you really do need to sue both sides of it unless there's a good reason not to.
Yeah, because e-Oscar is actually required, like it's spelled out in 1681I, the electronic communication mechanism. And so, I mean, if they're saying, it kind of gives you the authority or the ability to say, hey, well, what happened with this electronic communication mechanism? If you're saying you didn't receive it, Mr. Furnisher, and right here in 1681I, it says that all nationwide CRAs shall maintain an electronic, mechanism to transfer dispute data to the furnishers. Well, let's subpoena or get some discovery against the CRAs and see what you did or what you didn't do, right? And so very, very interesting stuff there.
Just one thing I'll say about that.
Yeah.
Sometimes you have these two groups, and in this group will say, hey, we didn't do anything wrong. It's all their fault. And so it could be a debt collector pointing the finger at the credit bureau or an original creditor. It could be a furnisher pointing the finger at the credit bureau. And so we'll kind of take that and embrace it. So imagine, Stephen, you're the debt collector. And you say, well, Equifax never told me about this. We'd say, that's great, Stephen. I'm going to need you to give us an affidavit, and you're going to just throw Equifax under the bus. You're going to be our star witness at trial. We're going to just beat the daylights out of them with you. And it's like, well, I don't know, maybe they did notify me. They get real nervous when you're like, let's start swearing under oath and you be our star witness. And they're like, wait a minute, we got a business relationship. We're not sure about this. Really, John, I was just lying to you, try to get you to, take less money. And so again, there's a principle. Yeah. I guess something in my eye. But there's a principle. Let's take their conduct or whatever it is they're doing, and then let's turn that back on them. So, we don't fight them on. We're like, that's great. We're going to barbecue the bureaus with you as our star witness. And suddenly then they don't have as much interest in that.
That's awesome. Well, let's see. We've got a comment in here, Warren Maxwell. He wanted to know if you send them certified letter trying to update the address or the personal information, and they respond with a thanks but no thanks, they don't fix it. At that point, can you sue them? And how do you judge damages based on them not fixing inaccurate personal information?
Yeah, it's a great question. So no matter what the dispute is, remember that standard is negligence. So it's not just that it's wrong, but we have to show that had they done a reasonable investigation, they would have fixed it. So we need to do more than just say, well, that's not my address. Let's give some proof. But let's assume we've done that and they just won't fix it. Sure, we can sue on that because it's any violation of the FCRA. I mean, there are some exceptions, but this type of thing, you can certainly sue. Now, the damages would be, is this costing me economically? Probably not. I mean, I guess it could be. Maybe you get turned down for a loan because you got some weird address, but probably not. Well, how about emotional distress, mental anguish? Yeah, I think you would have that because, again, it's somebody is keeping this record on you that you have no control over, and it's wrong. It's just flat out wrong. And you tell them it's wrong, and they go, I don't care about you, Stephen. Well, I mean, obviously that would make you feel like they're being contemptuous of you. They have no respect for you, and they're saying you're unimportant. Well, that's going to bother me. Now, is that $1,000? Is it $5,000? Is it $10,000? Is it $50,000? The kind of the devil's in the details there. How can we prove this under the law? And if it's reckless, you can always get punitive damages to punish them for that. So, I would say in general, that's going to be, not a very big case, but it should get their attention. And if they don't fix it, again, those attorney's fees are stacking up, and that, often is what drives them to settle these cases. They're like, okay, you caught me. I don't want to keep paying my lawyers and your lawyers. Let's just fix this thing and make it go away.
All right. Can you hear me?
Yeah, I
think I had a little, I pushed the wrong button here. So,
okay.
Yeah. Now, one way that you can manufacture evidence, I don't even know. Am I allowed to say that? Hell yeah, I'm allowed to say that. One way you can manufacture evidence that the personal information is inaccurate is to submit it in the form of an affidavit, assuming what you're saying is truthful, right? Because then, if you don't just, I mean, it's one thing to send it certified mail, and it's one thing to get your signature notarized, but it's another thing to say affidavit of fact. Now you want to make sure what you're saying is truthful, but like if you've never lived there, then say you've never lived there. But if it's an obsolete address and you can no longer, I mean, maybe you lived there a long time ago, but it's obsolete and really has no more value. Say this is an obsolete address and I can no longer receive mail here, even if you tried mailing it. So, you want to just make sure you're wording it correctly. But, if you send an affidavit, then that in itself inherently is evidence. Would you agree with that, John?
Yeah, I mean, it's something for them to consider. And, so look, if you're beyond that, what is it, 12 months to have your mail forwarded by the postal, I think it's 12 months. Then if it's an old address, you don't live there, you don't have any connection there, then it would be truthful to say, look, I used to live here. I don't live here now. I can't receive mail. And if you've never lived at a place, there's sort of an expression, it's hard to prove a negative. Like, how do you prove you never lived there other than saying, I never lived there? It's like, how do I prove I've never been to the moon? I don't know. I've never been to the moon. Like, there's not much more I can do other than saying that. And so we've got to be truthful when we do it. And an affidavit can be helpful. We've done affidavits before. And a bureau can say, well, I reject that, or I don't care. That's fine. They can do whatever they want. They can say, we flip a coin to make decisions. The question is, did they get it wrong? And was it unreasonable what they did? Because if it's wrong, it's unreasonable, then it's going to be at that negligence level. Yeah. So the more proof we give them, the higher the standard is for them to meet, or they will be considered negligent.
So Warren's posting up, he said it was the address for a lawyer who sued the debt collector. There you go. Looks like, okay. Warren, looks like you've got, just go back to the lawyer and tell him he can go ahead and sue the furnisher now, or the CRA this time around. So.
Yeah. And look, I had a situation where I was moving and there's going to be this gap. Like, we left this place and we had a place being built, and there was like a several day gap. And so I just said, you know what, just forward mail to my office, because we were going to be in a hotel for like a week or 10 days. And so suddenly on my credit bureau now, it's got my office address. And well, yeah, I work there, but that's not where I live. And certainly what Warren's talking about, I guess a lawyer, whether it's for Warren or somebody else, but a lawyer sues and they pick up that address, and that's pretty easy. Like, that ain't my address. That's my lawyer's address. You'll be seeing that soon.
Yes, sir, he'll sue you to get it removed, and then you'll
Yeah.
put it back on again, and then, it'll just be a vicious cycle until you, remember that time, like maybe 10 years ago or something, there was this Greek guy, and his name was God, and Equifax, their systems like wouldn't let a consumer with the name of God because they thought it was a fake name or something.
Oh, okay.
So like, and the guy was like, well, it's a Greek name. I'm Greek. And yeah, that's like how you spell my name or something. And he ended up winning like a whole bunch of money from them or something. Do you remember that case? It like made it on a newspaper and stuff, like Equifax's procedures, this poor guy, and they're saying that he can't exist and have that name.
Yeah, it's
you remember
I
seeing
don't
that?
remember that, but I have sued Equifax and some of the others for saying we're dead, and I have my client write a letter saying I'm not dead, here's the proof. And then Equifax will respond and say, well, we've investigated it. You are dead, but if you disagree, you can write a 100-word statement. And so we put that in the lawsuit and we say, apparently Equifax thinks we can reach from beyond the grave to write a 100-word statement because they've already decided we're dead. And they don't think that's particularly funny. I thought it was pretty
Get the
good.
picture, hold it up with like the newspaper with today's date, and hey,
Yeah,
I'm
just
risen from
crazy
the dead.
stuff. But yeah, what Warren's got there, I mean, that's really good. That's a fun case. So
Yeah.
yeah, I think the judge who reads that case, the lawsuit, will get a chuckle out of that.
And then we had Elvis posted up whether, we would recommend posting up the credit report, including it with the dispute, like first round or when you would do. And so, I mean, I guess it all depends upon what you want to do. I mean, typically what I do is my first round goes to the bureaus and I put them on notice of everything that's wrong with the trade line, all the fields, and I include copies of the credit report trade line. And I'll send that same data audit to all three bureaus because I'm comparing it against their one standard, which is Metro 2. They all use the same industry standard. So, and also Innovis uses that same standard as well, right? So you have four bureaus, four different CRAs where you can compare the trade line and figure out like, why is this thing reporting differently? So, and like John said, he doesn't necessarily always send it, but I think if you're, in the business of credit repair, I mean, part of the value is showing them what's wrong with their printed report because like, I mean, we know that two of the three bureaus are not going to give you a date of first delinquency. And that's a super important field when it's a negative account. And so again, I mean, if you're trying to take, make the case to them that it's inaccurate, they're going to look in their system and the furnisher is going to look in their system and probably see that there's a first delinquency date in there. We can just assume that these two bureaus just don't put it on their template. And I say we can assume because, I mean, we really don't know for sure, right? I mean, we have no idea when you sue them and they're like, well, we have the date of first delinquency and you show them the report and it's not. I mean, that's why you have to sue them because it's like, I mean, well, is it not on your template or, what's the deal, right? And you should never assume things. That's why you have to state the facts. And the fact is, date of first delinquency is missing. And here's a copy of your credit report, as evidence of those facts and stuff like that. So I'd say there's no specific whether you should put in the report or not, but I always do. And I mean, I guess it just kind of depends upon your process. And
Yeah, and I would say, Stephen, I mean, I don't see any benefit of holding anything back. I think we talked a couple of weeks ago about, if you've got 10 negative accounts that have errors, like dispute all 10. Don't say, well, I'm going to do 2 and then 2 more. And like put all the reasons, all the inconsistencies, all the missing information. And so if you want to include the, like a physical copy of the credit report or drop it in, to the Word document, do that whenever you want. I mean, we don't have to ramp things up. I mean, we can just hit them, you can walk up to them and punch them in the face right away and say, and then if they don't fix things, you can hit them again or you can sue them, whatever you want. But I just don't see any advantage in holding anything back.
punch him in the face. I like your style, John. I like your style.
Figurative, by the way.
That's right. That's right. The figuratively. And so
we'll probably be banned from Facebook because of this video now.
I think they're already, they're probably, we've already got one leg in the grave with Facebook. We'll see. We'll just be broadcasting through our Telegram channel.
That's
here.
right. That's right. So we have Stephen always has a backup plan.
That's right. That's right. Which, by the way, go up to our units. We've got a Telegram channel you guys can join. So Floyd actually posted a really good question. How can you remove an old address on Experian that is attached to a negative account? So I'll kind of take this one first, and then we'll let John. I mean, so obviously the spirit of the FCRA, and if you look at the very beginning of it, it's to make sure that the information is relevant. And I mean, if it's an old address that mail no longer comes to you, then it's irrelevant. So then the question is, well, there's a couple parts. So number one is, with the address, can you go to the furnisher and tell them to update the address, right? Like, are they still reporting the trade line, or are they not reporting the trade line? And so in other words, what I mean by that is, it may be a negative account and they stopped furnishing it 2 or 3 or 4 years ago, and so it hasn't been updated. If you can go to the furnisher and change your address with them, and if you can then dispute it with the bureaus, the trade line, the bureau's requirement is to record the current status. So I mean, like, if you go to the furnisher and say, hey, furnisher, this address is no longer valid. My current address is this, so they should update their address. And then if you dispute the trade line through the bureau and say, well, my address should be this to your current address, and if they don't fix it, then there's a problem. So that's kind of the address thing. And then there's Experian's like systems and procedures, which basically just is that it's almost impossible to delete an address that's related to a current account or an account that you have. So, I mean, what I would say is the way you would get around that, it would be changing the address to your current address, and then you can try to delete the old one. What are your thoughts on that, John?
Yeah, I mean, look, it's a little bit of a gray area on previous addresses. Okay, so if I used to live at 123 Main Street, let's say 5 years ago, they're reporting it. Now, if they report it as my current address, I mean, I can dispute that. And if they don't fix it, I can sue them for that. But they say, well, this is an old address that used to be my address. I don't know that I would sue on that. But like you said, Steve, I mean, go to the furnisher, because they'll, like Experian will say, well, we cannot delete this because it's tied to, certain account. We'll figure out what account it's tied to, get that furnisher to update. And, sometimes this is all, it all kind of loops around. I mean, you may find that there's an account that has not been paid, but they've just stopped updating it. Well, that gives you a basis, because we know you're supposed to update every month. And so you can dispute that account. You may be able to kill that account. And then if there's no address, I mean, if there's no account that bad address is tied to, then you can get rid of that bad address. But I mean, if it's like Warren's example, it's my lawyer's address. Well, that's fabulous. If it's an old address that is legitimately your address in years past, it's a little harder. I think most bureaus will do it. Experian seems to be a little bit difficult. So I think your idea, Stephen, of going to the furnisher, like, hey guys, you got me at 123 Main Street, update that to 789 First Avenue. Then they do that, and now Experian will, be more cooperative.
And then Richard had posted up earlier, I think you had a question about some late payments. And so, I mean, if you have something specific with late payment, go ahead and post it up. If it's something, well, I mean, if it's, kind of that we can chat about in here, if it's something more specific, feel free to shoot me a message, Richard. We can definitely talk about that, if it's a specific case that you have. Okay, then we've got Alan. You've contacted the original, or you say contact the original creditor, and they informed you that the debt was handed over to a collection agency. Debt collector tried to convince you that it was your debt. You told them to send me what you thought they owed within 5 days. Let me see, how does this, within 5 days, and you received a letter stating that verification, but no 1692G notice. Okay, rights were in the letter. Okay, so I think what you're trying to say, Alan, is like, when they sent you the initial communication, you didn't get the FDCPA 1692G notice. So I guess what somebody like John would have to determine was that in fact their first communication to you?
Right.
Was their initial communication? And yeah, that's definitely an issue if they don't send you that. What do they call it? The mini Miranda or something? And then
that's part of it. Here's the challenge is that the law says they must send you that 1692G notice within 5 days of first communication, they must send it to you. It doesn't say you have to receive it. So amazingly, no debt collector has ever admitted that they did not send it. They always send it. They're like, I'm sorry, you didn't get it, Stephen. And so that's part of the challenge if you're, suing on that is they can show that they sent it. And then we get into a fight. There's some legal stuff called the Mailbox Rule. And, if I didn't receive it, what's the presumption? And it gets a little complicated. But, so I don't really sue over that. But, with that, when they're responding to you with, verification or validation, you can see what they're sending you, what you requested. Did you give them a reason for why you need it? And again, think of that as a tennis match back and forth, going back and forth with that collector. So,
Yeah. Let's see here. And then she's got two brothers that are like very close in relationship as far as date of births and everything. One of them has terrible credit, one has good credit. And then
that's always the case.
Some trade line from the brother with good credit got deleted, even though that wasn't the one that they were disputing. They were disputing the trade line for the similarly named and birth dated and everything bad credit brother. So, how would you address the fact that they took a dispute and they interpreted, I guess in this case, they would interpret it under the wrong consumer, right? Like if you got two brothers, their names are almost exactly the same except for middle initials and everything else, like they're twins or something. And maybe they have a similar trade line, I suppose. If you have a good trade line that gets deleted, I mean, when you didn't actually dispute you as the consumer, it was a dispute for your twin brother. I mean, I'm not sure if you would really have any remedy for that per se, right? I mean, because they can delete and stop reporting at any point in time. I mean, what would you say about a scenario like that where a good trade line is removed from a brother with good credit when it was never intended to be or even disputed?
Yeah. So, broadly speaking, that's a mixed merge file because these files have been mixed together. And those are really good cases. So we just want to look and see, okay, presumably the brother with good credit disputed saying, hey, my brother's got some bad stuff on my report. Now, if they took off the bad stuff and they took off some good stuff, well, then there may not be much you can do. But if they left the bad thing and took off a good account, then you could sue them for that. Because again, it's a lousy investigation. And we have this idea of it's under 1681 EB. So reasonable procedures to assure maximum possible accuracy. Well, they're supposed to prevent these files from getting mixed together. If you think about George Foreman's kids, I think they're all named George in some form or fashion. So they may have some trouble, things getting mixed together. But still, they have different social security numbers. And, even if they live in the same zip code or even the same house, so I would just say everybody who's watching, when you have clients that they're a junior, a senior, a third, a fourth, or they have similar names, you've got to really watch for this. And if you dispute it properly and they leave that bad thing on there, then sue them for that. So, I'd say let's just take a look at exactly what happened. Again, kind of the before, the during, and the after. What did it look like before the disputes? How about during the dispute process? And now after the dispute process, what does it look like? And there may be a case there.
Yeah, and then so let's see. So Floyd, back to the address issue. So he's saying, can you, with Experian, they'll verify based on the address. Can you send an affidavit to the CFPB? I mean, I think there's a couple issues, Floyd. So number one is, how do you get through their system, which their system is like uses those addresses. If it's related to the account, then that is part of their system versus, I mean, the CFPB is not going to care if like, I guess it doesn't get deleted because of the address, but if the information is inaccurate in some way and it doesn't get deleted, then certainly, you could send that to the CFPB. So I think it's important to distinguish between trying to manipulate their systems, and I use manipulate not in a bad way because these are just big electronic technical systems, versus like, I mean, you're not going to go to the CFPB and say, well, I don't know, the address, because of the address, they didn't delete it or whatever, but it should be, well, because it's inaccurate, I put them on notice and here's how I put them on notice, they didn't delete it. That would, I think, be the best way, for dispute it there.
Yeah, and
let's see.
add to that, Stephen, is
yeah,
if you have an old address and it's tied to a negative account, I wouldn't worry so much about the address. Let's kill that negative account, which is what you were talking about there. Like there's going to be errors on that negative account. So that's where I would focus, because if you kill that negative account, the address will fall off. That's easy to get rid of. But if you're trying to get rid of an address that is tied to a current negative account, that's going to be challenging. So I would focus my energy on, let's find the errors in that negative account.
Yeah. And then let's see, Nikki, your question was at 1681 EV. So I think it's 1681 EB. John, were you talking about the maximum possible accuracy?
Yes,
part?
yeah. So
Yeah.
B is in boy. So
Yeah, 1681 lowercase e and then B in parenthesis thingies. 1681 EB is where the maximum possible accuracy provision is spelled out there. Okay, cool. So, all right, keep the questions coming. We've got a few more minutes here. We can chat a little bit, and so, but so give us, as we're kind of, I mean, we've got about probably maybe 10 minutes left here, John. You're in the courtroom all the time with these bureaus and stuff, and things change all the time. What would you say would be like a good juicy one versus something that, as credit repair folks watching this, trying to figure out how they can partner with a law firm, which, by the way, those of you guys who are watching, John is like super amazing and super accessible. So feel free to reach out to him. He's in here on the show, obviously, because he's amazing, but he would like to be able to get business from you as well. Wink, wink. So, but he's super accessible. But for those folks who are watching here, like, what would be something good for them to know? Okay, they can send this over to you versus like something that probably wouldn't really be a very litigious type scenario.
Well, I'll try to answer a couple ways. One would be, just imagine, like, forget about lawyers and all that. Just imagine you're standing in front of a federal judge and there's, Equifax saying, we didn't do anything wrong. And the judge is looking at you saying, well, prove to me they did something wrong. You don't want these, kind of pathetic letters that just say, please verify all information, because I think all information is inaccurate. Like, what does that mean? It doesn't mean anything. So the more specific we are, very, very specific and very clear about what is wrong, now a judge can read that dispute letter, because that's really the basis of these cases, is the dispute letter and then the results that come back. And so that dispute letter just needs to spell it out. And I'll see people that will have very short letters. And I say, why didn't you add more detail? Like, why didn't want to use an extra page? Use an extra page. It's okay. You can use 2 pages or 3 pages or 33 pages. I mean, we've had dispute letters, like, not talking about attachments, but just dispute letters that might be 10, 15 pages long, single space. It's okay. Like, use as much time as you need to use. It'd be like us saying, we're going to do a training course on how to dispute under the FCRA, and we're only going to give ourselves 2 minutes. Well, you can't do very much. Like, that's an hour, that's 5 hours. I mean, you need, it takes as much room as it takes to communicate, okay? So make your disputes very, very, very clear and understandable. And then you generally have a good case when that doesn't get fixed. Now, just sort of broadly speaking, identity theft that doesn't get fixed, those are great cases. A mixed merge file is a great case. Things where you have sort of objective proof, so I've got the closing statement from when I sold my house, and the loan's been paid off, and yet they're still reporting a balance on it. Well, that's easy, because it doesn't rely on the consumer testifying. It's like, we can prove our case without the consumer. Again, what I described at the beginning of the show, some debt buyer sues me and I beat them in trial. And then I take that order and I say, judge, or I say to the credit bureau, look what the judge said, judgment for defendant, me, the consumer. That's easy, and so you take away any excuse that these guys have, and just understand they will lie. They will purposely misinterpret what you're saying. They'll look for any little wiggle room to get out. So you want to sort of close all options for them so that they have no escape on this, and they have to investigate and fix or delete. And when they don't, that's a good case. So just try to anticipate, like, what's the most ridiculous argument they could come up with, and close that off. So we might say, look, here's a letter from AT&T saying our account has been paid in full. This means I owe nothing. In case you're confused what paid off means, it means I owe nothing. And so just spell that out to the bureaus, write it to them like they're, I don't know, fifth grader or something. Maybe that's giving them too much credit, but because there's some smart fifth graders, but just like spell it out in detail. Every field that you challenge, I would end that paragraph with, I need you to fix this or delete the whole account. So they don't say, well, I didn't know Stephen wanted me to delete the account if I couldn't fix it. No, spell like every paragraph, spell that out. So that's what leads to a good case. Now, the last thing is damages. If you have a mortgage broker send you a case and there are errors and you dispute it and they don't get fixed, and you send your person back to the mortgage broker, they're like, I still can't get them approved. That's a great case because we have damages. That's lots of economic damages. So just be on the lookout for those.
Yeah, and I mean, damages is something that should be fairly simple for most of our clients to get. I mean, if they're coming in with bad credit, even if it's something as simple, if they aren't coming referred from like a mortgage person, have them go online and apply for a credit card or something like that, and have them apply for one of the good credit cards, and they're going to get an adverse action notice. They're going to get declined. And so, I mean, as far as being able to get damages, it's as simple as have them apply for something and either get declined or get unfavorable terms.
Yeah, let me just say something about that, Stephen. So there's sort of this weird thing in the FCRA where if you imagine a timeline, and so I dispute here, and let's say I get turned down for credit here, and then they do a lousy investigation here. Well, usually I can't get the damages. It's only the damages after the lousy investigation. So we want to dispute and they don't fix it, don't delete it. And then we apply for credit because look, we may get approved. I mean, I've had people with, like really bad mortgage errors. And yet there's one broker that will give them a loan at, like 3% interest. You're like, hey, like keep applying. You may get lucky. But even if you don't, this shows the damages. So just imagine this timeline. We want the damages occur after the lousy investigation. So before it's nice, and it might be that EB claim, B as in boy, but the strongest claim is almost always the 1681 I for investigation. And that you want the turn down after the investigation.
Yeah. We had a question, which states do you practice in? So you're in Alabama and Alabama, right?
Yes.
But you've got a network all over the place. So I mean, obviously, and then we've got quite a few attorneys who are in this community group and stuff. So feel free to reach out to John, even if your consumer is not in Alabama, and he can definitely facilitate putting something together for you.
Yeah, and the other thing about that is, unless we're talking about a little local company, we can sue these guys in any state. So I can sue Equifax in Alabama, no matter where the consumer is. I can sue Portfolio Recovery in Alabama, no matter where the consumer is. And that gets into jurisdiction, things like that. But just understand, we can either sue in Alabama or, there's a lawyer that we've worked with in virtually every state. So
how do you get jurisdiction if the consumer is not in Alabama? How do you get jurisdiction in Alabama to do that?
So we look at jurisdiction in a couple of ways. There's something called personal jurisdiction. That's the power of the court over the person. Well, we have personal jurisdiction over, like Equifax, if they have what's called continuous contacts with the state of Alabama, which they do because there's 5 million people in Alabama. There are 5 million credit reports. Okay. Portfolio Recovery files 1,000 lawsuits a month in Alabama. So they have enough contact here. And then the question comes up, well, how about on the consumer? Well, the consumer can always consent to jurisdiction in any state because they file the case. So when you file the case, you consent to the personal jurisdiction there. So I've never been in South Dakota. And if somebody sues me and I've never been to South Dakota, that case is no good. But I can always choose to go to South Dakota to file a lawsuit and submit myself to the power of the court. So
Yeah.
it's really not, anything that's difficult.
And Shadera is asking how she can get in touch with you. So yeah, send him a message. You can send him a Facebook message. He is on there. He's also got an amazing YouTube channel. Is it an Alabama Consumer Protection Attorney or something like that?
Yeah, and my main website's alabamaconsumer.com. And so we've got, contact forms there and YouTube channel, or just go to YouTube and hopefully if you put in our name, it'll should pop up.
And then Sam had asked, so what happens if you request the dispute notation to be removed, which obviously for getting mortgage qualifications, that sometimes can be a deal breaker from the underwriting side. And if they don't remove it, how would a judge look at that?
Yeah, that's an interesting question. I've never known the bureaus to not remove that if you ask them to. So just thinking out loud, if you've withdrawn your dispute and you say, I no longer dispute this account, but yet they keep it, consumer disputes, then I think it's sort of ironic. You'd have to do a dispute to remove the dispute.
It is one of those ironic situations.
Yeah, it's sort of like the Matrix, but you would also potentially have that EB claim and say, hey, this is not accurate because I've withdrawn my dispute. So like I said, I've never seen that, but yeah, I think you could ultimately sue on it. It would be interesting.
Because the interesting thing is because that really comes to more of an underwriting issue. I mean, because you have disputed it, but then you use the phrase withdrawn, which I guess, okay. I guess if we want to get all technical, like the FCRA doesn't say you can withdraw a dispute, right? So well, once it's disputed, it's kind of always disputed, but it's kind of this common thing where no, they'll remove it. It's just kind of this common understood thing where you call them up or contact them and they will definitely remove it. So it's one of those kind of little gray areas that's not really, but because of underwriting requirements, you literally want this thing to not show you in dispute, even though you're still angry with it.
Well, it does bring up an interesting point. So there's a case that's very famous called the Saunders case versus BB&T, I think. It's about 10, 12 years old. And it's where you make a dispute on an account and the furnisher tells the credit bureaus, don't mark it as disputed. Well, why would they do that? Well, because it doesn't count generally in the scoring models. Well, the FCRA says if you make a dispute, it must be marked as disputed. Now, the courts have interpreted that to mean it must be a good faith dispute, legitimate dispute. And so some of these furnishers have said, well, we'll leave the dispute notation on there. And actually Metro 2 is kind of pushing them towards this. But then as soon as the dispute's done, you remove that. Well, that's not what the law says. So Metro 2 can say that and that's cute and everything, but that's not what the law says. So once you make that dispute, it stays on there unless you tell them you're not disputing it. And so I think if you say, you know what, I no longer dispute that Capital One account, then they would have to remove that. Like I said, I just have never seen it, but if somebody runs across it, I'd be very curious about that.
Well, the other side of the coin is, whether there's any sort of potential case against the mortgage lending companies for the way that they're doing their underwriting guidelines, if that potentially is contrary to the language of the FCRA. Because if you've had something that was disputed and they're saying, which the consumer exercised their consumer right to dispute, so it's a consumer right, are they now discriminating against the consumer in any part of a credit transaction by saying you can't be underwritten if you've got something that shows it's in dispute, which, would that be potentially a credit discrimination type issue? So, these are kind of we can go down the rabbit trail all day long on there, but I've often thought how kind of weird that is that they're saying they're going to deny you credit for you exercising your consumer right to dispute it based on something the consumer has no control over. So if you want to look for the next class action, John, maybe we can figure that one out, huh?
Yeah, it can make your head hurt thinking about, okay, if it's disputed, it doesn't get counted in the scoring. So the mortgage companies say, well, we can't then process you if you have a dispute. And then, well, what is Fannie and Freddie and all these guys?
Yeah.
It's all related, but
and then I guess as we kind of kind of wrap this one up here, Barry had asked if there's a way to get paid. He's a credit repair owner. If there's a way to get paid when clients come to you. And so I think, we were talking about this before the show started, but there are definitely some legitimate ways where credit repair companies, can get compensated, where it's not like, like getting, attorney fees and things because we're not attorneys. So, if somebody were to send a case to you as a credit repair owner, what are some ways where they could structure that relationship with you, John?
Yeah, so I'll give you kind of two general ways. One is certain states allow lawyers to pay kind of a lead generation fee. It's like, hey, you're giving me this lead, I can pay you X number of dollars. My state does not allow that. So the other way to do it is, and all this has to be legitimate, okay, is I'll have folks that run credit repair organizations, they'll send me a client and then I'll say, hey, I want you to do this work for me, kind of paralegal type work, but basically organizing the file. Okay, if a consumer comes to me, they never come to me with everything organized. It's like all this, crazy box full of stuff where it's on a Google Drive. And I've got to go through and organize that again, kind of like before, during, and after. Or I pay somebody on my staff to do that, or I can outsource that to somebody. And just because I need it in a form that I can look at it and say, yep, we can sue these companies for these claims. And so it's obviously easy for the credit repair place that did the disputes to be able to organize that file, And so, I personally don't do much on an hourly basis. It's more of what's the value. Somebody might hire me and it's, I spend 30 minutes, but it might be worth a lot of money, for them. And, it's the old joke, the plumber comes out, and like does one thing and charges you, $500. And you say, $500, you're here for 5 minutes. So he changes the bill to say, $1 for where to hit the hammer, $4.99 for knowing where to hit the hammer, And so, that's a way that if there's true value and work being performed by the credit repair organization, then they can be paid for that. It gets a little complicated. Well, when does that work happen? And we can certainly talk about that. But what we cannot do is there cannot be like, well, this is a bigger case, I'm paying you more, you get a percentage. That's where, all the states say, no, you can't do that unless, you happen to be a lawyer owning a credit repair place.
But if your CRO is running for politics, you can give them a briefcase full of cash as a campaign contribution, and that's okay, right?
I think dark money is okay.
Like if he's running for a local judge, a CRO company, you can contribute to his campaign, but you can't give him a marketing fee. So, okay, that's kind of a joke, guys, but but not really, because it's kind of crazy how things work. But so one of the benefits though, if somebody comes to you with a credit repair company and you can put them on like as a paralegal per se, I mean, there's no licensing requirement in Alabama, and I'm in Texas. There's none in Texas, to be considered a paralegal. And the benefit there is you're now kind of in a privileged relationship, so you can talk to that CRO and your conversations are privileged to a certain extent. What about like expert witness, being able to compensate somebody for consulting expert? I mean, is there a point where maybe, okay, the prep fee paralegal thing, we've kind of gotten past that. Now, we need to escalate you up to like, we can compensate you this other way of being an expert. Do you do anything like that as well? Is that a possibility?
I think it's possible. I personally haven't done that. In a sense, when I say to a paralegal fee, what I'm talking about is somebody organizing the file. Here are all the disputes. Here are the previous credit reports, the subsequent credit reports, maybe the turn down. And usually that person will then say, and here's what I think are the violations. So whether we want to call that an expert, consultant, paralegal, it's just something that it generates value. So again, for me, I can't pay somebody simply for saying, hey, here's a potential client, but I can pay somebody for work they do and for value that they provide. And so, there are ways to do this where it's all above board. And, because I have no interest in risking my license. I told somebody, I'm not good for anything except, suing these companies. So, I don't want to have to get a real job. So, I'm going to keep everything very, within the bounds and the rules. And there are ways to do that. And, the other thing is, if you have a relationship with a lawyer, there's value if you can contact that lawyer, even on a case you're not sending, but say, hey, I'm dealing with this, how would you word this? Or is this right or wrong? And so, you just look at the total relationship and the value there.
You don't look good in an orange jumpsuit is what I'm hearing.
Yeah.
You'll leave that to the political ruling class.
That's right.
They would all look good in that. So that being said, obviously, if folks want to get in touch with you, John, you love credit repair companies. You team up with a lot of them. You're a friend of this community in here as well. What's the best way for them to get in touch with you? Obviously, Facebook messaging. You've got a YouTube channel. And then obviously, if you guys want to learn more about pre-litigation disputing, and all things therein related, using powers of attorneys, learning how to read a credit report based on Metro 2. Matt and I do have our pre-litigation training course, $99 a month. John is actually a member of that. That's how we became such good friends and stuff. And so feel free to shoot me a message if you're interested in that, or you just want to grab a phone call and chit chat about your business in general. Feel free to shoot me a message. Would love to talk to you as well. So that being said, we'll go ahead and wrap this one up. We come to you with this show the second and fourth Thursday of every month. And the first and third Thursday, we have Expert Witness with Doug Miner. And so that being said, we'll wrap this one up. Appreciate all you guys for joining us, and we will see you on the next live. You guys take care.